Good morning, folks, and welcome to our webinar on regulatory prosecutions. My name is Brian Horkan. I'm a partner and head of our health and prosecutions team. I started my career nearly 20 years ago as a district court prosecutor in the DPP's office, and since then I've kept up a mixture of civil and criminal work for regulators. I'm joined by Shane Reynolds, who's a partner in our team, having joined us in 2013, having previously spent almost 10 years in Michael Staines' renowned criminal defence practice. Our third speaker is Lorcan Staines, Senior Counsel, who's one of Ireland's leading criminal counsel. Lorcan, as well as having a busy general criminal practice, has also been involved in some of Ireland's highest profile regulatory or white collar crime cases. He's also a frequent public speaker, and as we'll hopefully show today, an innovative embracer of technology to enhance the presentation of cases. The style today is intended to be conversational, and I'll chat to Shane and Lorcan about recent developments in criminal law affecting regulatory prosecutions, including looking at evidence gathering, presenting that evidence, and challenges getting cases heard at the moment. We hope to chat for about 30 minutes with questions after that for 10 to 15 minutes. Feel free to submit questions as we go along in the Q&A. Well, I suppose without further ado, Lorcan, I might just ask you, this is something that comes up for us from time to time. Really, how would you ensure mobile phone and computer data evidence is admissible? And we're thinking here sometimes even including emails and text messages. And again, what do investigators need to bear in mind when obtaining other technical evidence?
Well, I suppose the first thing to consider would be the basis on which the material has been taken in the first place. So whether that's by way of a search warrant or some other sort of a production power, or whether you're purporting to do so by some sort of consensual arrangement. And obviously you want to be as careful as you can in terms of the basis on which you're utilizing. And also that even if you do have a statutory or legal basis for taking material, that you have been careful to define the material as narrowly as possible in circumstances where if you're just going for a complete trawl of a business's records, one, you're going to totally find yourself in a scenario whereby you're going to be overwhelmed by the amount of material you have. But secondly, an argument could be later made at trial that this was effectively a trawling exercise rather than a specific and targeted one. So that's the first thing to consider. If you're happy with your lawful basis for taking the material, then you will need to be thinking about your chain of custody. And my advice to investigators is always to keep your chain of custody as tight and as short as you can. So you shouldn't really have more than a couple of people dealing with any device. In an ideal world, you only have one or two dealing with the device in order to keep your chain of custody as tight as possible. Take contemporaneous notes. Note where the material is being put. If there's numbers on the bag, note that in your contemporaneous notes. If there's anything particular about the device in question in terms of how it looks, note that in your contemporaneous notes. All of that material is going to assist if there's any argument later about chain of custody. And then after that, in terms of ensuring that it's admissible, you can never ensure that something is admissible. But if you take the steps that I've just suggested, you're going to do everything you possibly can in terms of getting the best chance at least of getting material in. The other thing I would say is you can probably take a contemporaneous note at the scene from whoever it is you're taking the material from. If you can get their written consent for taking the material, even if you have a statutory basis, that can be of assistance, a kind of a belt and braces approach. And the other issue you're going to have is probably access codes. So again, if someone's being cooperative with you at the scene, is prepared to give you access codes for the computer or the device in question, but also if there are programs on the computers that will have passwords and so on, if the person is prepared to give you them consensually, that's going to help you an awful lot. For example, if it's an iPhone and you don't have the code, while it can be got into, it's extremely difficult to do so. So you want to try and get the access codes if you can.
And just in terms of that, I mean, I suppose some of the regulators we deal with, they have complaints from the members of the public, and they might be wanting, or people they're dealing with, they might show them text messages and things. I don't know, maybe if your background maybe with the Gardaí might seize that, but where it might be less practical for them to maybe seize the phone. To me, it seems it's just like you're saying, it's just to get maybe just to get a copy of those messages, but just have a very clear record of how you got them, what you were, what the conversation was with the injured party at the time, so you can be sure that that there is a sort of a probity or a chain of custody in relation to them. Any thoughts on that?
Well, obviously, people's mobile phones and their computers are very personal items. And because of the way business is now operated on mobile phones, there's a huge mix of personal material together with potentially interesting material from a investigative perspective, and work emails, work texts, so on and so forth. So that is a big issue. And if you find yourself with no statutory authority to take the device, and if someone has been cooperative with you and is prepared to share material with you, then you're into the next best scenario. And the next best scenario would be to identify text messages of interest, so to speak, and you could do a screenshot scenario and take the material. Now, that is very much next best. It is not the best. And the difficulty with that is an argument can be made later that the text messages have been selectively taken. The device is now gone, or it was never taken into custody in the first place. And therefore, an argument could be made by someone to say, well, you've taken a selective portion of the material. We have no opportunity to look at the actual device itself, and there would be a decent chance of the material not being admissible ultimately if you took that next best scenario as I referred to it. So obviously the best is to take the device if you can, but that's not always practical in circumstances. And
isn't it the reality, I suppose, that while the rules are the rules in terms of admissibility and chain of custody, if you take the example, if it's a murder trial versus maybe the context of the text message is more important than, say, somebody who's arranged maybe with a gas or an electrical installer. If you don't have the full context, it depends on the circumstances, maybe what leeway might be given and the importance of the context.
Yeah, absolutely. Well, first of all, if it's a murder case, you've got much more scope to use more draconian powers in terms of seizing something. So that won't necessarily always be the case for something less serious. And secondly, depending on what court you're in, and depending on what judge you have, and depending on the context of the case, you may have a situation where something of a lower level of terms of chain of custody might be allowed in by the particular judge on a particular day. So what I'm talking about here is best case scenarios, and they don't always exist. So like sometimes a practical approach has to be taken.
Thanks very much for that, Lorcan. Maybe if I might jump to you, Shane, next, just in terms of following on, I suppose, from what Lorcan is saying, is sort of tying in around taking evidence. And I think you looked at just recent case law around voluntary admissions, but this is something that comes up all the time for us as well. So if you want to talk to us a little bit about that, Shane, it'd be great.
Sure, Brian. Yeah, well, I suppose, firstly, just to say, often regulatory prosecutions are complex issues, and proofs are often quite difficult in cases. So to have admissions can be very important in any prosecution, but particularly in regulatory prosecutions. And just in terms of voluntary caution statements, which is primarily the main focus of investigators' interviewing techniques. There's a recent case from last year, Health Products Regulatory Authority versus Rossi, which copper fastened, I suppose, the voluntary caution admissions and their admissibility. Essentially, this was a case where a lady owned a beauty salon, and it was alleged that she was selling Botox without prescription. And the officers from the HPRA went into her beauty salon, found the Botox products, and proceeded to ask her questions under a voluntary caution.
This is a public service announcement. The court service,
which she was.
Hey, don't worry about that. This shows how live and real this webinar is. We're live, broadcasting live from the CCJ. But sorry, go on. The lady had, I think the investigator had come to her beauty salon. So, yeah, I think.
Exactly. So essentially, the High Court was posed a question from the District Court as to whether voluntary cautioned interviews, which are conducted not pursuant to any statutory provision, whether they are admissible. And in essence, the High Court decided, yes, they are admissible. And the High Court was compared it to a situation where a member of the public makes a admission of guilt to another member of the public. That in itself is fundamentally admissible. I suppose the main takeaway for investigators out of that case is to conduct interviews in an organised fashion. This was done by two officers. One officer asked the questions, the other officer took notes, and the usual fair procedures apply and were carried out in terms of the suspects being offered an opportunity to read the statement and make changes if necessary after. So,
yeah, Shane, my sort of old-fashioned take on that is that, you know, isn't it? It sort of depends on what they know at the time of the statement, and depending, you know, the level of when it becomes an investigation and when it becomes an interview. Really, are those kind of the sort of the basic principles to have in the back of your mind?
I think so, and obviously you need to know, are you interviewing a witness or a suspect? And if a witness becomes a suspect during your investigation, during your discussion with the person, you should immediately pause and inform the individual that they are now a suspect of whatever particular crime it is, and caution them. And I suppose that ties into when is a good time to caution someone. And there's no real answer to that apart from the fact that you should always caution a person before you start asking a question. But if someone blurts something out to you before you caution them, that doesn't mean that admission isn't admissible, as so long as you caution the person immediately after that, and you know, ask them to if they want to repeat what was said before.
Yeah, I think I always go back to my old-fashioned example, and I don't have the case reference with me now, but it was O'Flaherty in the Supreme Court saying that, of course, the guard who comes upon somebody in the middle of nowhere with their car in the ditch can ask them what happened. But I suppose once they get a smell of a drink and the person says that they drove it into the ditch, maybe at that point, a caution might need to be administered as a sort of an anecdotal, old-fashioned way of looking at things. Does that make sense?
I think so, and again, that's exactly the scenario that the High Court compared it to in the Rossi case. And I suppose a lot of our clients in regulatory investigations, a lot of the underlying legislation provides for offences which are important offences so offences such as providing false or misleading statements to an authorised officer, or perhaps failing to comply with a direction of an authorised officer. Again, the same principles apply. Fair procedures, you should warn the person that they are potentially committing a criminal offence if they don't comply with direction, or if they, in a statement, provide what you think is false and misleading evidence, because it's quite a high threshold for you to say that, you know, someone's statement to you is false, that it's a criminal offence. It must be fairly obvious and implausible comment or statement made for that threshold to be carried out. And again, contemporaneous notes, obvious point, but again, all should be taken. And again, the suspect or witness offered the opportunity to sign, read over the notes at the scene itself.
And just in terms of finessing that for COVID-19, I suppose you're saying the same basic principles apply, but have you any thoughts? Just, I mean, at the moment, maybe that interview might be happening by telephone, or other thoughts on that, or have you any feedback on that, Shane?
Yeah, I again, it's not something that was, you know, done pre-COVID, but I know from speaking to certain authorised officers that something they are now doing is phoning witnesses, and if the witness consents to it, and clearly this is for a lot of witnesses, say a timid witness who be less inclined to attend for you know, the offices or meet someone, might be more favourable to making a statement over the telephone. Once again, the fair procedures statement should be written up after the telephone conversation, should be posted to the suspect or witness, again, given the opportunity for them to review it, sign it, send it back if they're happy with the contents. And just important as well that any correspondence between the authorized officer and the witness suspect, that is inherently open to being disclosed to the defence as relevant evidence. So just be aware of that any correspondence.
I'm conscious, Shane. Yeah, just in terms of that, we could probably talk all day about statements, and lots of people have got themselves in trouble. But like, I think if the thing to remember there is that you keep it a record. We could even possibly have talked about, how the extent to which you could send out or pre-populate a statement with maybe just with non-leading questions. But I think that's an interesting one that we'll come back to with people again and again in the coming months. If I was to move us on to our next question, and just think, because it's something we've chatted with Lorcan about, and we're fascinated, I suppose, about it, in terms of how does paperless evidence work in practice, I suppose, particularly when you're presenting some of this, when we say complicated technical material, but even things as maybe more visual material like the mobile phone data or the text message that we referred to there.
Well, I think in the current climate, in terms of COVID-19, obviously all lawyers and those involved in the process are seeking to get their cases on, and it's a very difficult thing to do in terms of the resources that are available, and particularly because our courts are set up not to deal with social distancing. So it's very difficult to see that we could get to the same level of cases in this short term. So in my view, that's going to result in scenarios whereby if you do wish to get your case on, you may be restricted in the amount of time you have, or you may just be seeking to present the case in a much more efficient way than maybe was possible previously. So paperless evidence in terms of technical evidence, in my opinion, the best way of doing it, and there may be other good ways of doing it, but the way that I use anyway is by way of PowerPoint, which is the program that you're using at the moment, Brian, but it's also a program that I wouldn't have used for a good few years. But when I came across using it in the last number of months, it seemed to me to have dramatically improved in what you can do in relation to it. So I'm doing a trial at the moment whereby PowerPoint has been used 6 or 8 times in terms of presenting evidence. Very good for presenting photographs, very good for presenting CCTV footage, videos of interview of an accused, for telephone evidence. And all of this can be put together in a type of what I would call a storyboard format, which can effectively summarize the case that the prosecution are seeking to make in the course of 10, 20 or 100 slides of a number of different types of digital media. So that...
Sorry, Lorcan, if we're getting into the nitty gritty of that. So what I'm thinking, are you then, say, segmenting, taking the really relevant part of the CCTV footage you want to show, and then are you clipping in maybe a video or a still? Sorry, I'm fascinated by it because I can imagine it's very persuasive to a jury.
Yeah, so if, for example, you have a 3 hours of CCTV footage, in the first instance, that will probably be cut down to the 10 minutes of relevance, we'll say, to the particular incident. And there's a function on PowerPoint where you can actually bring that 10 minutes of footage in, and then you can trim it down to 10 seconds, 20 seconds, 50 seconds. And that will become a little small video clip on a PowerPoint slide, which has your 10 seconds of interest. You can then add to it in terms of words or commentary and so on and so forth. And you can then move from slide to slide. So if, for example, there were 6 clips from that of the overall CCTV footage that you were interested in, they could be all clipped into separate slides, and they could be mixed with photographs, and they could be mixed with commentary, we'll say, of an expert Garda or an expert prosecution witness to indicate to the court or the jury what it is that the court is seeing, which is also something the Court of Appeal has allowed to happen in recent cases. And therefore it takes a lot more advanced planning, but once it's done and once you prove the underlying content, you can have a much more streamlined actual case, and also a much more convincing one, really, because it's more efficient and it looks better for the court in question. And I think that's going to become particularly important in the post-COVID-19 situation, whereby, for example, we have 22 courts in the courts of criminal justice, but because of social distancing, very often a trial might take up 2 or 3 courts, and that means that there's going to be substantially less cases able to proceed over the next 12 months than would ordinarily be the case. So I think the time that people are going to have is going to have to be restricted.
Lorcan, can I take it that lawyers, and I don't know whether this applies equally to barristers and solicitors, they don't necessarily have a reputation for being innovative. So I'm guessing you might get a bit of pushback against, you may have got a bit of pushback, but you've pushed and you've kind of pushed on through that. And my second question will be, I suppose this is both for you as maybe the prosecuting counsel in particular, but you've no problem with maybe your witnesses doing this, or so it's an option for both to present their evidence. Really, it's just the question is that I suppose it's also useful to disclose the PowerPoint presentation as well, presumably to help deal with some of that pushback.
Yes, well, like with any crisis is going to present an opportunity, and definitely those people who are more open to new methods of dealing with complicated issues are going to probably have better results than those who are resistant to change. And look, there is always resistance to change, but the fact of this crisis will make, I think, courts more receptive to dealing with this type of material. And yes, I have come across some resistance to it, but the answer to that is simply this is the way that we're doing it.
Yes.
In terms of disclosure, absolutely. I always think from the prosecution's perspective, the easier you make it for the defense to understand what the case is, the better chance you have of cooperation from lawyers for the defense, and the better chance you actually have of pleas of guilty. And pleas of guilty are obviously extremely attractive to prosecutors in the current environment, where the amount of court time is going to be restricted, because it's always an advantage to a defendant if they're told, listen, this trial isn't coming on for 2 years, or this case isn't coming on for 6 months. Turkeys don't vote for Christmas. So if they're told they can have that length of time, they're going to take it. So the easier you can make it for the defense, the better. And therefore, if you have created a PowerPoint presentation which summarizes your case neatly, disclose it.
Brilliant. Thanks, Lorcan. I think
disclose it in early course. Better chance.
That nearly enough leads us into our next question, maybe for Shane, when we're talking about I suppose particularly in regulators in the district court, just to talk to us a little bit about fines and the payment of those, which obviously it's either after a finding or a plea of guilty. So if you were just going to lead a little bit on that, Shane, it'd be great.
Yeah, and I know I got a number of queries in this last year from state authorities. I think there was a general kind of query in terms of the Fines Act in 2014 as to whether that was working, and in terms, so essentially the 2014 Fines Act has really removed only as a matter of last resort the imprisonment on foot of non-payment of a fine. So the position now with the 2014 Act is that firstly, I suppose three main factors the court must take into account, which is always the case anyway, but statutory footing now, the financial circumstances of the defendant. Secondly, installments of the payment of fines is now an option for the judge instead of paying it in one lump sum or a lump sum. Or three, then if a fine is not paid, there is a further court hearing for a judge to decide whether other options can be looked at. So options such as a recovery order or an attachment order against the defendant, or a community service order, and only as a matter of last resort is imprisonment looked at. So again,
just in the last point first there, just in terms of that, that's almost, on my reading of that, it's almost like it's almost like a quasi-civil process, but it's nearly a process as between the court and the person against who the fine is made. It kind of almost goes away from the prosecuting authority at that stage. Am I reading that right, or have you any thoughts there?
Yeah, no, exactly. And there was a again recent High Court case last year on this. Judge Eager decided in DPP and Fogarty, and this was essentially the prosecution didn't turn up to the subsequent hearing in terms of the what order the court made for non-payment of fine, but and the defendant took umbrage with that. But essentially, the High Court decided the prosecution's role ends once the conviction and fine is imposed, and it's really an administrative matter for the court services at that stage. So So, and I think it's important as well, Brian, just on the fines part. And again, a lot of legislation, I know there's some people here from local authorities on the call, under the Waste Management Acts, also under the Electricity Act as well. A lot of legislation now provides for fines to be made directly payable to the prosecutor, as opposed to before it was paid directly to the court service, to the Exchequer. So that must be on application to the court. I've never had a situation where a judge has refused to make the fine payable to the prosecution. So that just to bear in mind as well.
And I think it's something for regulators as well. Lots of them get their investigation costs. It's possible to have those ordered too. But I think maybe those that don't might be a sort of legislative change they want to look for in the coming years. What do you think?
Yeah, and the cost part is, as you say, Brian, it's whether you look for your full costs or a contribution to costs, and this comes into, I suppose, the general, what is the purpose of a regulatory prosecution? And regulatory prosecutions are a bit different from straight normal, we'd say, criminal prosecutions, in that often it's not just about penalising the offender, because in a lot of these cases there isn't actual injury to a person or to a property, but it's more a general safety message to get across and to act as a deterrent. And of course, the judge must take that into account, but the judge also must take into account the circumstances of the defendant. So often, regulators will want a message to be sent out, which would is as a result of a conviction being recorded. And obviously, if a judge is imposing a full cost order against someone, it may be a case where a judge will decide not to actually record a conviction, which, in my experience of most of our investigating clients, that's their primary goal, is to get a conviction recorded against an individual, to send out a message to the general public. Yeah,
and I think that the reality is that, like you said, on costs, different judges will almost have their own informal view of how much it should be paid, and it'll very much go on the means. So it may be that even if those powers are there, it's not feasible. I mean, sometimes even if a very high cost order is made, or very high fines, it's almost counterproductive in terms of any payment. Is that your experience too?
Yeah, exactly. And the courts will obviously, there are cases where full costs can be looked, if there's a particularly egregious set of facts, or if there's a wealthy defendant, or lengthy court proceedings as a result of the behaviour of the defendant. So there are situations where you may look for full cost, but generally, a contribution cost is and especially with a fine now being payable to the investigator and a conviction recorded. I think, sorry, my advice would be that would be a decent result for an investigator.
Okay, well, then maybe just moving on to our next, I suppose. I think Lorcan's already talked about this a little bit in terms of the hearing of regulatory prosecution. So I might just ask you, Shane, first. I mean, what's the situation on the ground for all the clients or regulators that are on this webinar?
Yeah, so there's been a few practice directions made by the president of the district court, and the situation currently is that in terms of criminal cases, it's only defendants who are in custody. Those cases are the only cases being heard. So obviously in regulatory prosecutions, that's rare, if ever, that a defendant will be in custody. So regulatory prosecutions are not being heard at the moment. Virtual hearings are being trialled at the moment and have been actually rolled out in some areas. So, for example, in childcare law and district courts, I know you've been involved in a couple of those, Brian, but I'm not sure the reality. Obviously, it's subject to public health situation, but it may be a case that that's overridden by. I'm up in court once a week, and I see more and more people attending court. So it may be a situation where that virtual hearings are overridden by actual reopening of courts to a certain extent.
But Shane, just in terms of delay and issues like that, the district court is still open in terms of issuing. The district court is still open for issuing of summons. It's not the situation.
Yes, exactly. They're issuing summonses. They're obviously giving dates. I had one raised 3 or 4 months from now. So, but once you've issued a summons, that's fine. It's not a matter for you as when the court gives a court date. And I think the courts will be more sympathetic, and very sympathetic, I think, due to COVID in terms of any delay in investigating, and I think there'll be valid,
It also probably ties back in with, I suppose, Lorcan's earlier points about if your case is clear. I suppose my sense would be that there's been some shortcomings. I think the court service in fairness have come up at very short notice with not a lot of resources with this sort of a virtual hearing, but there's some limitations in terms of that, in terms of witness or sort of live drop-offs and things. But I couldn't see any reason why in the coming months there wouldn't be able to sort of deal with the routine part of the case as sort of a first listing and disclosure, and maybe entering pleas. Lorcan, I don't know if you have any thoughts in terms of whether it would be any fairness issues in terms of, I think a trial is probably beyond us, but in terms of entering pleas virtually, would you have any concerns with that, or would you be reasonably happy with that?
Well, I personally wouldn't have any concerns with it. The criminal law has had a little bit of experience dealing with this because of the concept of video link evidence. And video link evidence was initially trialed in relation to young people and vulnerable people. And over the years, it has become a little bit wider in the context of when video link evidence can be used. And up until pre-COVID, it would have been for child complainants, vulnerable complainants able to the prosecution, for example, Australia.
Yeah, I think, funnily enough, I'm involved on the technology side with the court service in relation to the trialing of this. I think what's happened is they've repurposed the software that the likes of yourself would have been using, and it works well when you're in a courtroom because if there's any drop off, everyone can see. I presume in the trials you're running at the moment, you're probably streaming into a room beside you because you can't be in a room with the jury. Is that what you were saying earlier, alluding to about 2 or 3 courtrooms being used? Is that how it's working?
Yes. So the current trial is in one courtroom. It is live streaming into another courtroom for those who are overflow. So for witnesses who may be attending or for members of the public, they can watch it live in the next courtroom. And then the first court can link with a witness overseas in the UK or the US. They can give their evidence. It's now a presentation. They can be shown a CCTV footage or photographs or whatever it might be by way of some presentation. And all people in all rooms can see that at the one time. And you can switch between 2 screens, 3 screens, 4 screens, depending on what you want to do. So it is working relatively well in that regard. And the Supreme Court have held that there is nothing in principle wrong with, there's nothing in principle that would stop a court allowing video link evidence, and they did not find that it created such significant problems for the defense that it was impermissible. So it'll come down to the discretion of the trial judge or the discretion of the district court judge, depending on the circumstance, as to whether it's appropriate. But again, I think that people are probably being too sensitive about this. And I do think you could enter pleas. I do think you could do pleas of mitigation. And I see no reason why you couldn't do hearings by way of video link, provided everyone was properly organized to allow it to flow efficiently, which is a big ask, I admit. But I think if everyone was properly organized, it could be done.
Yeah, no, I think that's been touched on in some of the practice directions as well. I mean, I think there needs to be, the problem is if there's a drop off and the technology doesn't show that, there needs to be sort of immediate, no more than we probably planned ourselves here in case one of us dropped off. But look, I suppose we're just like any good host, I'll try and keep us roughly to our timings, but I don't know about good, but I'll move on to I suppose, just to sum it up, because I see quite a few questions have come through and I'll try and throw some of those to you now. So if I was just to move on to our takeaways. I mean, I think, Lorcan, I think we're, even in talking to you, I'm making new resolutions about the use of PowerPoint, but particularly about the trimming, because I know I've sat through maybe longer than necessary presentations. And I think we're saying that both investigators and prosecutors, solicitors, barristers should be doing that and making their own presentations and disclosing them in early course. Shane, I think you're very much, you've touched on voluntary caution statements. they are admissible, and really we just need to focus on that when it goes from an investigation, someone being a witness to a suspect, is if you bear that in mind. And I suppose the other one for us is that court offices are open, they're issuing prosecution summonses, and like Lorcan has said, I think we just need to stay open-minded and push this as far as we can. If I was to bring up my Q&A here, I think we had initially someone saying, do we anticipate that the post-COVID, the taking of witness statements will continue to be taken remotely, or will this become a fair procedures issue where it's no longer necessary in public health grounds? I think we've already answered that to a certain extent, but Lorcan, I don't know if you wanted just to give us a take on any sort of better safeguards there, or if we were doing that, or any views.
Well, I think the big issue in terms of taking witness statements is transparency. And obviously there's been very significant issues in cases where there hasn't been transparency in the manner in which a statement was taken. In a lot of ways, a statement taken by way of email, as in where a draft is sent and then it's sent back and then it's sent again, provided all the drafts are disclosed and the comments in the emails are disclosed, that is an extremely transparent way, in fact, of a statement being created, and it's provided to the defence for them to assess completely how the statement came about. Again, if it's by way of phone or by way of Zoom, I don't have a huge difficulty with it, provided all contemporaneous notes and all communications are disclosed. And you know, there may be some issues over signing of the statements, but the signing of the statement isn't strictly necessary in circumstances where the height of what a statement is what the prosecution expects the evidence of the witness to be. And ultimately what's important is what the witness actually says in court, rather than what they've said in their
Yeah, and I think, like you
statement.
said,
now, if you've got witnesses who cooperate and don't cooperate.
Sorry, I cut across you. But I think, like you said, the use of the technology actually means there's scope for recording and that, so it's possible to be even better, I suppose, in terms of your transparency and your open disclosure. I think just going through the questions, there's someone, Caroline Conroy's asked about a reference for the Rossi case, and we'll circulate that after to the group. And I think what legislation and guidance that we've got what legislation and guidance available for caution and interview of suspects. Shane, have you any thoughts there? I mean, the basic principles were always sort of the judge's rules, and then, like you say, the Rossi, I think, is a case that folks, from memory as well, they go through a bit of the historical case law as well around that, the principles. Yeah,
I suppose the judge's rules are primarily in relation to the draft in relation to police interviews of suspects in custody. But in saying that, they do have general practice in terms of regulatory prosecutions as well. Again, the whole point of the Rossi case is that there was no express statutory provision. This is the case for most interviews carried out by regulators, and really that makes it a bit easier for investigators, as long as they carry out fair procedures in terms of again, issues such as informing the defendant of their right to consult with a solicitor or not. There's issues around that, but informing them, cautioning them is important. It's very kind of, we take as common sense stuff, but maybe not. Again, we've spoken about it today. Writing up the statement after giving the person the opportunities to review it after. Again, stuff like not allowing the witness to give their own account, not leading the witness, not cross-examining the witness during a voluntary caution statement. The role of the investigator is, of course, to seek out information, but they of course mustn't put words into the mouth of the witness. So that's the general, I suppose, principles on it.
Yeah, and I suppose, sorry, if I'm jumping around a little bit, but I think there's a few questions coming up here, but there's one of the questions that was about mobile phones being retained in an investigation, and I think, or is an image of the phone and data sufficient? I think in a way, I think, Lorcan, you've kind of already answered that in that I suppose it's a great lawyer answer, it depends, but there's a reality to taking someone's phone depending on the type of investigation. And if you don't have their phone, it means what you lose is perhaps access to the full context. And it'll depend, I suppose, on the seriousness, what we're saying, the seriousness and the relevance of the case as to whether you require all that context. I'm not sure. I think, Lorcan, I'd be saying that you probably already answered that as you went along, but if there's anything you wish to add on that.
Yeah, well, in terms of how long you retain it for, if you have it properly imaged by somebody who is with forensic capabilities, and you can call that person to say, I imaged the phone correctly, I wouldn't have a huge problem with the phone being returned to the individual, but I would be writing a letter to the defense indicating this is what you intend to do, and getting their agreement, or at least the fact that you inform them of it before you hand the phone back, so that you can defeat an argument later that they have now lost something. For example, they may want to get their own expert to oversee the process by which the phone is imaged.
Okay, and
I wouldn't have a huge problem with it, because it would mean that that issue was dealt with in early course.
But I suppose it'll depend on the level and the nature of the prosecution, whether, you know, an investigator might say to us, look, that's simply not possible for the cooperation of the witness. But I suppose if they're not taking the extreme cautious approach, then there is potentially a risk, but it would depend on the nature of the case, I suppose. Isn't that it?
Absolutely, yeah. And so, for example, if you are taking screenshots of a conversation between two people, I think that the investigating officer should make sure that they're looking as best as they can be sure at the full context of the conversation, and that all relevant portions of the conversation are obtained. For example, you know, a conversation that's only taken halfway through could be very misleading if the first 4 or 5 text messages were not taken. So screenshots of the entire amount of the conversation would make it more likely that the material would be admitted.
Yeah, and I think I've had that in a civil case.
It's the second best process.
Just even the same thing where if you've disclosed, and it took a bit of work the first time, but there was, you know, 24 pages of WhatsApp messages, and they all had them, and it worked fine, and the people they had a chance to speak to their context. Because I think there's a question in here from Greg Ford as well, and I think it's coming back to this, is in presenting video highlights, how do you avoid the accusation being presented in a manner to influence the judge or jury by showing all the bad bits in quick succession? And a video without sound is also risky, as the person making the video may be inciting trouble, but maybe not be on the video. I mean, I had that myself in a case lately where the person, that was very much their argument, but I suppose it's for everybody to put the prosecutor has obviously a responsibility to put context on it and how they tell the story, and it won't do them any favors if they don't do that. But in my case, they said they were being incited, and then they punched the person in the face. So I think that, you know, the judge or the jury will listen to the context they want to put in it, and they'll put that to the witness, that they can't dispute that context if they weren't there. But I presume this is the kind of pushback you probably had, Lorcan, in that you've referred to, that people were not necessarily open to it. So do you have any other takes on that?
Well, your question is quite right. The purpose is to influence the judge or jury. That's what you're trying to do. You're presenting your case, and you are trying to influence your tribunal. The fairness requirements requires you to disclose the entirety of the material from which your clips or your selections have come from. And if the defense are to suggest that it's been selected unfairly in any way, they can show other portions to show that you have been unfair. Now, if it is shown that you have been unfair, that's going to be very damaging to the prosecution in the eyes of the court or the jury, as the case may be, so you'll be very careful as to what you select. But ultimately, all the material is there for all parties, so anyone who wants to raise any particular issue can do so. So, and that's the best way to defeat any argument of selectivity, is to be transparent and disclose all material of relevance, so that all parties have an opportunity to address the issue at hand.
I think there's an interest coming back here. Sorry, I should say, Shane, you have a shout out from Paul Hanna just to say that that there was the court was going ahead in Castlebar yesterday for a hearing arising from prosecution. So it's good to hear that. It's probably good for people to hear that across the webinar. That, you know, I think, like Lorcan has said, you need to be proactive and you need to push for these things to go ahead. I thought there's a question there that ties into that. Are warrants more difficult to get presently? And I think that, Shane, again, you know, I think we'd be saying is that the logistics of that might be a bit more difficult, but I think we've got to say that, you know, the courts are very keen to say it's business as usual. I can't imagine any district court judge not being willing to facilitate you getting a warrant.
Yeah, and I suppose those two. Thanks, Paul, for that. Let me know Castlebar is open for business. And in fairness, it's like as you can imagine, the district court. There's a practice direction from the president of district court, but what we do is we've cases all around the country. We check with each individual court office as to whether cases are proceeding, because judges have in their own districts have their own autonomy, let's say. So that's the first thing to say, is that they're as a general principle, they're not hearing, and that's been my experience. The warrants issue, yeah, no warrants certainly are being applied for. Again, it's just anyone's aware is generally warrants are applied for in chambers, and so judges will, you know, that and sounds pretty easier to manage than in an open court. And again, certainly that's happening, and that's, you know, not coming under the practice direction. His warrant hasn't been looked at. So and again, what we often do is we would attend with the auditor's officer sometimes to assist with the judge if need be, and if there was some relatively new, you know, investigative power being carried out, just to assist if required with legislation.
Well, look, I'm just looking at the questions here, and we've plenty more there, but I'm very conscious of time, and that people have given up their time to come to us and trying to stick to that timing. What I would say is that I suppose myself and Shane and Lorcan may be willing to help us as well. We'll certainly try and take a look through these questions and maybe see where we can go in the future with them, and maybe certainly people feel free to give us a call or anything that they want. I mean, the next steps from us, I suppose, is just really to thank everyone, in particular Lorcan for joining us, and then to thank everyone for coming on the webinar. We'll send a recording of the webinar along with a survey for feedback, and I suppose for future topics, to everyone who's attended. And just thanks again for all your time on this, and hopefully be chatting to lots of you again in the future. Thanks.